Yes, Mr. Chairman. May it please the court. In the rest of the time I have available, I'm going to deal, if I may, with the right of abode and with the consequent topic of Pomachowski. So this is sections 6 and 3 of our printed case, and then section 7. I hope I can do this reasonably swiftly, and if the court will forgive me, not always turning up every reference. The issue in relation to the right of abode is whether the right to enter the UK as a national, as part of the right of abode, is a civil right for Article 6 purposes. Obviously, if it is, then the imposition review may arguably determine a civil right in a much more direct way than the route taken by the Court of Appeal. The judge said no. I've shown you where she said that in Judgment 1, and when she formally had to decide it in Judgment 3, she adopted what she had already said. And the Court of Appeal accepted that at paragraph 117, that's in bundle page 117. The Court of Appeal accepted that there was no Strasbourg case that had ever decided that the right to enter one's country is a civil right. And it's notable, and perhaps for the first time in my life before this court, that the QX has not cited a single Strasbourg case to disprove that proposition. There simply isn't one. Strasbourg has not pronounced that this right is a civil right at all. And in these circumstances, we respectfully say that the starting point is probably Lord Brown's well-known dictum about no less but certainly no more. That is in Alskany. Can I just give you the references? Alskany's, it's bundle 1214, but the relevant passage is paragraphs 105 and 106 at 1268. And then the case of A.B., in which Lord Reed gave the leading judgment, that's at page 1060, and the relevant passage is paragraphs 54 to 59 at page 1084. That says it all much better than I could possibly try to do orally, so can I just invite the court, please, to look at those references. We say that the upshot of all of that is that for the domestic courts now to hold, in the complete absence of Strasbourg authority, that the right of abode or the right to enter is a civil right for Article 6 purposes would be far, far more than the incremental development that is allowed. And it would trigger the danger pointed out in both Alskany and A.B. if the court's decision were to prove to be wrong. And so the starting point is that this is not a step that this court should take in these circumstances, and that would, in fact, on its own really be enough to make good this argument. But can I then go on, please, to proffer 4 reasons to think that actually if Strasbourg were to look at it, Strasbourg would hold that the right of abode is not a civil right. The first of these reasons is the sort of general bedrock principle of the distinction between what are civil rights and what are rights, maybe public rights or public authority prerogatives, is the phrase used by Strasbourg, that are not civil rights. And for this, the leading authority is the case of Ferrezzini, which I mentioned earlier. Can I please ask to turn that up? That's in bundle page 1858. And you'll see just from the heading there at 1858 that the complaint in question was the length of tax proceedings, and that was what's triggering the complaint about a breach of Article 6. If you can please go to page 1863 in the bundle, paragraph 24, it's towards the bottom of the page. The court refers to the well-known proposition, the concept of civil rights and obligations cannot be interpreted solely by reference to the domestic law of the respondent state. The court has on several occasions affirmed the principle that this concept is autonomous within the meaning of Article 6. And the court confirms this case law in the instant case. So that's a good place to always to get that from. And then at 25, it goes on to say pecuniary interests are clearly at stake in tax proceedings, but merely showing that a dispute is pecuniary in nature is not in itself sufficient to attract the applicability of Article 6.1. There's then a quotation of traditional case law. And then at 26, the court goes on to say, well, what about present day? Does a living instrument doctrine require us to do something different? And at 27, the court went on to explain how relations between the individual and state have developed during the 50 years since the convention was adopted, with state regulation increasingly intervening in private law relations. Like, I'll just pause there. That's important because that gives a clue as to why it is that the court sometimes finds that things are within the civil rights rather than just public authority prerogatives. This has led the court to find that procedures classified under national law as being part of public law could come within the purview of Article 6 if the outcome was decisive for private rights and obligations. And pausing again, there's then a list of examples of such cases. So to give some examples, the sale of land, the running of a private clinic, property interests, the granting of administrative authorizations relating to the conditions of professional practice, or of a license to serve alcoholic beverages. Moreover, the state's increasing intervention in the individual's day-to-day life in terms of welfare protection, for example, has required the court to evaluate features of public law and private law before concluding that the asserted right could be classified as civil. So again, if I could pause there, there's clearly the flavour. You're looking for some effect on private law activities in order for a right to be classified as a civil right. At 28, the court went on, rights and obligations existing for an individual are not necessarily civil in nature, and they refer to political rights and obligations, which are not civil in nature, consequence that Article 6 does not apply. Neither does that provision apply to disputes between administrative authorities and those of their employees who occupy posts involving participation in the exercise of powers conferred by public law. Similarly, the expulsion of aliens does not give rise to disputes over civil rights for the purposes of Article 6, which accordingly does not apply. And the reference to the citation there is Mulweer, you see in the footnote. In the tax field, developments which might have occurred in democratic societies do not, however, affect the fundamental nature of obligation on individuals or companies to pay tax. In comparison with the position when the convention was adopted, those developments have not entailed a further intervention by the state into the civil sphere of the individual's life. The court considers that tax matters still form part of the hard core of public authority prerogatives, with the public nature of the relationship between the taxpayer and the tax authority remaining predominant. And I think it was Lady Rose who asked me earlier where you get it from. That is the place where it normally is taken from.
Can I just interrupt just for a moment? Back in paragraph 27, footnote 7. Now, this is talking about the granting of authorizations relating to conditions of professional practice or a license to serve alcoholic beverages, and references to Ringeisen, first of all. And I always wonder about that, whether that might be relevant, because you're talking there about proceedings which determine whether I can do a precondition for being able to enter into contracts to sell alcoholic drinks to members of the public is the obtaining of a drinks license. And it's because I think the reasoning in Ring Ice and a later case called Ceramic is that because the ability to enter into contracts is a civil right, and the obtaining of a license is a precondition for being able to enter into contracts. That's why Article 6 attaches to the license hearing. Now, it might be argued that there's an analogy.
Yes, I can see the potential for such an argument. And when the domestic courts, our domestic courts, have looked at this, and in particular, I think the leading case cited by my learned friend is G and X School. This court explained how there was, in effect, a spectrum of cases. At one end, you've got cases where the proceedings are clearly directly decisive, and at the other end, there's what Strasbourg calls a tenuous or remote connection.
Yeah.
But between them, you can see how that there is a spectrum, and I entirely accept that where you've got something which is so directly involved in private law, so for example, selling alcoholic beverages, that might be something that the Strasbourg court would take into account in deciding that proceedings A must also therefore comply with Article 6.
Mm-hmm.
But the what the court is looking at in Ferrezzini certainly for its decision in Ferrezzini, is also what is the nature of the right that is being decided in Proceedings A, because that also is important. And in Ferrezzini, they're saying, look, money is money. You can see how the right to money could be private law, property interest. But the nature that these proceedings are to do with the relationship between taxpayer and state, and that has not changed, and that is so hardcore public law, public authority prerogative that Article 6 does not apply. I think in G, this court observed that really it's a sort of pragmatic case-by-case approach that Strasbourg takes. And I'm sure my learned friend will refer to it, and I may have, if I need to, come back in reply on the detail of that. But that is fundamentally what this court said in G. And so while I accept the point that Lord Reed puts to me, was that, is this one of the considerations involved? I don't think I'll disagree with that. But it is also important to look at the nature of what is being decided in Proceedings A. Tax proceedings, very much public authority prerogative, therefore it's not Article 6, even though there is money involved. And what we say on that is that Mawia, cited here in Ferrezzini, Mawia, when it's looking at expulsion, directly looking at expulsion of aliens, and recognizing the private law consequences of that for employment or family life or home, no, that is still entirely public authority prerogative. Article 6 does not apply. And so, I've already made my submission about how our case fits into that part of it. It's Mawia, Mafta, and the Pomachowski adoption of MT Algeria and Chahal. This is where our case sits. If you're looking for examples on a pragmatic case-by-case basis, this is where we are. The related question, which is what my submissions here are to do with, is look also at the nature of the right itself, the right of abode, the right to enter the country. That is hardcore public authority prerogative, because there is really no private law element whatsoever in the decision of a state as to whether to admit a particular individual into the country. There's really nothing less private or more public than the control of entry of an individual into the state. even though, as Mawia recognises, it may incidentally have repercussions on private law rights. So that, we respectfully say, is reason number one that to think that if Strasbourg were asked, Strasbourg would say no, the right of entry is not a civil right under Article 6. The second reason is one that's been cited by Strasbourg, both in relation to aliens and nationals, which is that the state parties have themselves recognised that Article 6 does not cover entry into the country. In Mawia, can I just give you the reference, because I've turned it up earlier. In Mawia, at paragraph 36, it's a couple of paragraphs earlier than what we looked at before. Paragraph 36, which is on page 2053, the court recognised that Article 1 of Protocol 7 gives procedural protections for aliens because the state parties understood that Article 6 had never applied in this area. We also cite a domestic case, BB, at paragraph 14. Sorry, the page references there are 1365 for the report and 1371 for paragraph 14, explaining how the state parties had understood that Article 6 never applied to immigration control of aliens. Strasbourg has also now looked at the position of nationals and the entry of nationals into their state. And in the case of HF, which is at paragraph 1874, and in particular paragraph 244 at 1956 and paragraphs 272 to 274.
What are the page numbers again, please?
Yes. HF is 1874.
Yep.
Paragraph 244 at 1956. And paragraphs 272 to 274 at 1964. They refer to the procedural protections in Article 3 of Protocol 4 for the entry of nationals. And the same reasoning applies because the states parties had understood that Article 6 had never applied to nationals either. For our purposes, neither protocol has any force. We have not ratified Protocol 4 and we've not signed Protocol 7. Article 6 just doesn't apply anyway, but their reasons in those two cases show that Strasbourg would, we say, decide that it's not right of entry is not a civil right. The third reason is that the right of entry is obviously closely linked to the right to citizenship and also closely linked to the right to a passport. But Strasbourg has recognized through the years that they are not, those rights, citizenship and passport, are not covered by Article 6. Citizenship is the case of Karasev, and that is in the supplementary bundle at 77, and the relevant passage is paragraph 3 at page 84, supplementary 84. As far as the passport is concerned, the case is Peltonen, which you'll find in the main bundle 2095, also paragraph 3 at 2102. We've cited two other cases, Smirnov at 2224 applies both of those previous cases. The relevant page for that is 2230.
Sorry, Mr. Chairman, I didn't hear the page reference.
No. Sorry, Smirnov is bundle page 2224.
Yes.
And the relevant passage at 2230.
Thank you very much.
And then
It's rather a strong authority because that's refusal to grant citizenship and a passport.
Yes. Yes. That's right.
And Article 6 doesn't apply.
Article 6 doesn't apply. This is a clear line of consistent authority. And then domestically, we also have the case of Harrison at 1442, bundle 1442. Can I draw attention to paragraphs 22 to 29 on 1446? And that's again, Article 6 not applying. So that's reason number 3. And reason number 4, about the linked rights or rights in relation to extradition also have authority that sorry, let me start that again. The extradition proceedings do not fall within Article 6. And I stress, and this is the moment to make this point, that it is not just the extradition of aliens, it's the extradition of nationals as well. For aliens, the authority is Peñafiel, which is at 2104. What we have done is to put in an English summary at that point in the bundle. We've quoted the relevant French phrase directly from the judgment in our printed case, but we thought that the English summary might also be helpful. And then that was applied directly in the case of Monedero, which is at 2077. And in this case, I would please ask to turn this up for a moment. At 2077, you'll see that the applicant is a Spanish national, and then under the circumstances of the case, he was arrested in Spain on an EAW issued by the French judicial authorities. And so the extradition was going to be from his country of nationality to France. The decision of the Strasbourg court is at page 2081. And under the quotation of Articles 6 and 7, the court says, right not to be extradited is not as such one of the rights and freedoms in the Convention and protocols. Furthermore, the extradition procedure does not involve the determination of the applicant's civil rights and obligations or of a criminal charge against him within the meaning of Article 6, and the citation is Peñafiel. The reasoning is all about extradition proceedings. As a class of proceedings, this is not within Article 6. It's not a question of nationality at all. And so we respectfully say that taking this authority, and Peñafiel, of course, is in line for authority, that's the fourth reason, good reason.
The date, what's the date of Peñafiel?
So, the case starts at 2077, and the passage of the decision is 208.
No, the date.
Oh, sorry, the date.
2002, I think.
Part April 2002.
Thank you.
I'm grateful.
Thank you very much. Was she?
There are two further logical supporting reasons, we say, for thinking that the Strasbourg court was right to decide in that direction. The first, can I describe this as the discrimination oddity, but then park that for a moment because I need to come back to it in the context of Pomachowski. The second is that in nature, the restrictions imposed by a TEO, that's a TEO itself, not the obligations, the restrictions imposed by a TEO are similar to, but although we accept more intrusive than, the restrictions that we all have on our exercise of the right of abode here. So, for example, we must come in through certain ports. There are control areas at ports. You've got to follow the prescribed route. You may be examined by an immigration officer, produce documents, have your baggage searched, and all of these things. It's very difficult to conceive of any of those routine restrictions being described as determining your civil rights. And so we say that if you've got TEO restrictions that are of a similar nature, that would be an additional supporting reason for thinking that the right of entry is not a civil right, and the restrictions don't interfere with that. Those are the reasons why we respectfully say that if the Strasbourg Court were to be asked to decide this, the answer would be it is not a civil right. That would be consistent with all of the authority that we have seen so far. And certainly it is not a step this court should take now to say, but the right of abode is a civil right, because there is no support for it.
Yeah.
So that brings me then to the topic of Pomachowski. Because there is not a single Strasbourg decision that the right to enter is a civil right, Learned Friends' printed case pins everything on Pomachowski. We respectfully say that, first of all, there are adequate reasons to distinguish Pomachowski from the present case. And there are, with respect, reasons for thinking that it may not have been correctly decided. And I'll go through those in turn. Can I ask to turn it up briefly so that we can see the relevant passage? It is at page 1597 of the bundle. But I think for present purposes, if I can ask to go straight to the relevant passage, which is at 1614.
So true.
Starting at paragraph 27. You'll recall this follows immediately from the previous discussion about Article 5.4. Mr. Halligan, said Lord Mans, also invokes Article 6.1. Secretary of State implies submits it's clear that Article 6.1 has no application to decisions to expel or extradite. A number of decisions were then cited. You see them all listed. Then halfway between letters F and G, Lord Mans observes that these were all cases concerning aliens. There's then a reference to Kirkwood, which is further described in 28. At 29, there's a citation of Mawia, and at 30, a citation of Mamatkulos. And then at 31, Lord Mans says, this examination of Strasbourg case law shows that the Commission and Court have stood firm against any suggestion that extradition as such involves a determination of criminal charge or entitles the person affected to the procedural guarantees provided in the determination of such charge under 6.1 or 6.3. The cases involved are all also cases involving the extradition of aliens. The last two decisions emphasize that proceedings for the extradition of aliens do not involve the determination of civil rights. By the same token, they underline a potential difference in this respect between aliens and citizens. And then there come a number of reasons why citizens were to be treated differently. The first one he mentions is that in international law and at common law, British citizens enjoy a common law right to come and remain within the jurisdiction. The authority cited is Blackstone, Boncool, Bagwan, and Van Dyne. And the conclusion that Lord Manson reached was at 32 was that in the circumstances, Mr. Halligan, and I'm going to quote here carefully, enjoyed a common, brackets or civil, close brackets, law right to enter and remain in the UK. And the reasoning was that, therefore, extradition, which would deprive him of that right for a period, determined his common law right, and therefore the proceedings fell within Article 6.1 because he was a citizen. Now, just looking at the decision itself, we respectfully identify 3 points, or potential points of distinction between our case and Pomachowski. The first is that Pomachowski is concerned with extradition or expulsion, not with entry. But our case, TEOs, concern entry. And so, although the rights are linked, they are actually different rights, and Pomachowski is therefore concerned with a different right from that with which this case is concerned. Now, I can almost hear immediately the objection that that's a point of high technicality, but actually that is a distinction which we find repeated in international law. If I can please ask you to go to Protocol 4, which is at page 1694 of the bundle. And in fact, turn over to page 1696 to Article 3. You will see the twin rights set out in separate paragraphs. 3.1, no one shall be expelled by means either of an individual or of a collective measure from the territory of the state of which he is a national. 2, no one shall be deprived of the right to enter the territory of the state of which he is a national. So you can see them expressed as 2 separate rights. And Pomachowski was concerned with the first of them, if it were applicable, expulsion rather than the right of entry. And that's important because Blackstone and Bonkel, which formed the bedrock really of the decision in Pomachowski, were concerned with expatriation. Blackstone's commentary is copied at 224, the relevant part is copied at 2254 of the bundle. And we've quoted, we've copied a longer passage at 2255 and 2256, from which you can see that the context is all about not being exiled and says nothing about entry. And Bonkel, of course, was also about being exiled from your home. And so we say there's a real distinction to be drawn here because the considerations that relate to expulsion may well be different from the considerations about entry. And so this is a proper point of distinction between QX and Pomachowski. The second potential point is that the interference with the rights is of a different nature. In Pomachowski, it was rightly described as, extradition was rightly described as depriving Mr. Halligan of a right that he was currently enjoying. The contrast is with a TEO, which controls only the future exercise of a right of which the individual cannot be deprived in any event. The third one is that you may think it's linked, is that the interference is of a different order or extent. In extradition, a significant period of time is likely to elapse, but in the case of a TEO, the interference can only be of a limited extent because of the reasonable time requirements. And we say that given that Strasbourg gives no reason to think that the right to enter the country is a civil right, it would be sufficient to decide this appeal by distinguishing Pomachowski on those 3 points. But we do go further and say that there are, in fact, 4 reasons to doubt whether Pomachowski was correctly decided in any event. The first of them relates to the right of abode. Lord Mance said that there was a common law right of a citizen to enter the UK, However, we respectfully say that the Immigration Act 1971, enacting the right of abode, which is clearly the right referred to in the 2015 Act, replaced the common law right with a statutory right. It must have done so because of what was done in the 1971 Act, affecting everybody who sought to enter the UK.
Does that make any real difference substantively? It may be a statutory right, but does it affect the reasoning?
Well, I suppose if one were to regard the common law right as coextensive with a statutory right, then we are probably just in semantic territory. I accept that. But for the purposes of this argument, it's not so much whether it's coextensive, but it's the steps that Lord Mance went through to reach the conclusion that he did. If he just said, well, he did just say, well, it's a common law right. A proper examination ought to have looked at what has statute done to the old common law right.
Yes, apparently we could be here all afternoon dealing with that, because it would take some persuading that a fundamental common law right had been taken away by statute, unless the statutory scheme was plainly inconsistent with the continued survival of the common law right. But as my lady says, it hardly matters. I mean, whether it's statutory or common law, the problem is Lord Mance's equiparating common with civil.
Yes, well, that is the next problem. Perhaps I can short-circuit it like this. We have set out in our printed case the materials showing how the statutory intervention has developed over the years, and we do make the point which we don't resolve from, which is that in 1971, sections 1.1 and 1.2 provided a statutory right of abode that covered everybody. So whether that was a replacement and abrogation of the common law right, or a statutory modification or an inevitable statutory modification of a common law right which continued to exist, probably doesn't matter. For the purposes of my argument, it is that it's the description which suggests that the court in Pomachowski didn't look sufficiently deeply into the question of what is the right of abode, where does it come from, and how wide is it now. For our purposes, what we do point to is that the right of abode that the 2015 Act refers to, in its current form, allows British citizens the right of abode, but does not extend that to many other types of British national. And second, it extends the right of abode to some non-British nationals, i.e. Commonwealth citizens, who are now no longer described in any terms as British subjects or British nationals. They are clearly non-British. And that picture shows how the right of abode now is clearly an immigration measure, and the judge was correct so to describe it.
Sorry.
Presumably you would say even if this common law right to which Lord Mance referred exists, that doesn't necessarily mean it's a civil right for the purposes of Article 6.
Absolutely, and that's one of the next ones I'm going to come on to if I may.
And clearly there are common law constitutional rights, of which this may be one.
Yes, it may be. But before
I thought you accepted that it was a common law right until 1971. Your printed case accepts that.
Yes, well that's right. Until 1971, Bhagwan is good authority for it being a common law right that's been modified by the 62.
And then you have to demonstrate an intention by Parliament to that it was should be dealt with entirely by the statutory provision?
Yes. As I say, my main point here is looking at whether there are reasons to doubt whether Pomachowski was correctly decided. The reasoning here is open to question. It's an issue that needed a lot more examination than was afforded to it. And we do point out that one of the curiosities of the decision is that none of this was in the parties' printed cases, so we don't really know where it came from, other perhaps than the fact that certainly Lord Mance had also been in Boncool himself, where similar language was deployed. But anyway, that's as far as I can take that. I'm not trying to argue the whole of the structure of right of abode today. The second point, as my lord and my lady correctly point out, is that he immediately equated a common law right with a civil right. And we respectfully say that does not follow, because this concept of the civil right is autonomous. You've seen the authority for that already. And as one example, a notable example, we've cited in our printed case the principle of open justice, which is a fundamental common law right domestically, but the Strasbourg court has repeatedly said it is not a civil right for Article 6 purposes. The cases are domestically Scott and Scott. It's 1623 at 1651. And then more recently, Kluger, 1452 at 1464. And then in Strasbourg, we have the cases of Hodgson, 1986, that's page 1986 at 1992, and Mackay, 2065 at 2070. So that's reason number 2. Reason number 3 for doubting Pomachowski is the observation that the Strasbourg cases only concerned aliens. Now, the Strasbourg cases that were cited by Lord Mance, I think that is right, but Monedero had already been decided by then, and that was clearly a case of a national. And you see from the reasoning that there's no distinction in nationality. That's the nature of extradition proceedings. And it's impossible to say that Monedero is an outlier, some single rogue decision, because it's part of this line of authority and specifically cites Peñafiel. And so, again, for the purposes of saying there are reasons to think that Pomachowski was not correctly decided, this wasn't gone into in detail. Monedero should have given some pause for thought, and it didn't. And the fourth reason is what I've described as the discrimination oddity. In the case of extradition, what has now happened is that because of Pomachowski, a citizen who's being extradited and who misses a time limit can ask the court for discretion to extend time, notwithstanding that the statute at face value has a hard time limit, which can't be extended. That's a result of HRA reading down of the statute. However, a non-national faced with the same time limit cannot ask for discretion. It's been pointed out that that's not unlawful discrimination because nationals and non-nationals are not comparable, but it is an oddity that somebody who has the right of abode can ask the court for discretion through HRA, but a non-national can't. Sorry, the domestic authorities, there's Lumenica in Supplementary Bundle 85, and then better reported Agadi, main bundle 1196 at 1206. And the point that I part earlier is this one, that if the right to enter is a civil right, then in a TEO imposition review, he has the benefit of Article 6 when he's exercising his right to an imposition review, or indeed actually one takes a step back, even to the right of entry for someone with the right of abode. A national with the right of abode and the right to enter the UK exercises a civil right on Learned Friend's hypothesis, but a non-national exercising the very same right of abode is not exercising a civil right and then can't claim Article 6 rights in the imposition review. It's not impossible, just like a Gardaí is not impossible, but it is an oddity, and the discrimination oddity, we say, is an additional reason for thinking that Pomachowski may not have been correctly decided. So our primary argument about this, as I hope we set out sufficiently clearly, is because of these oddities and because of these good reasons for thinking that Pomachowski might not have been correctly decided, there are additional strong reasons for distinguishing it and rather than following it. And that, again, would be sufficient for the appeal to be disposed of in our favour. But there's an implicit suggestion, I think, in Malone and Friends' printed case. Why are we being diffident about just saying Pomachowski was wrongly decided and inviting the court so to hold? And I think perhaps even an implicit suggestion that we don't have the courage of our own convictions on this. Can I just explain briefly why we take the position that we do? We're very conscious that Pomachowski was an extradition case, and we are not dealing with extradition. So we don't have all of the materials that might be brought to bear when looking at the consequences of a decision one way or the other. And we certainly don't have them at our fingertips. So there are two particular things. One is that we could not properly assist the court with an analysis of the consequences of Pomachowski being held to have been wrongly decided. And also, we do not know whether there might be reasons to say that the decision in Pomachowski was correct, albeit for different reasons than those given by Lord Mance at the time. And that is why we think that we should just be cautious and not just jump feet first into this particular topic, and primarily confine ourselves to inviting the court to distinguish Pomachowski and to hold what we say Strasbourg Court would hold if it was asked to do that. But ultimately, if push came to shove, then our backup submission would be that if you need to overrule or hold that Pomachowski was wrongly decided, then we would go that far if it's necessary for our appeal to succeed.
A point you haven't mentioned, but might be relevant, is that it could be said that the decision on any view went further than Strasbourg had ever gone.
Yes, well, yes, that is right. It had.
And Lord, you mentioned earlier Lord Brown's dictum, and this might be regarded as a case that is in conflict with that dictum.
Yes, and I suppose that is right, because there was no Strasbourg authority directly on point. Mm-hmm. And I suppose I should cite that, greatly adopt that as an additional reason for doubting it.
I thought your first point was that Lord Mance was incorrect to equiparate a common law right with a civil right in Strasbourg terms.
Yes.
But that inevitably means that you're saying the decision was wrong.
What our criticism was the automatic read across. The way that he put it in that sentence that I read verbatim, that it's the automatic read across that is a reason for doubting whether the decision was correct. I mean, obviously, it's not impossible that a common law right is a civil right. There are many such rights. But it's the structure of the reasoning in those paragraphs of Pomachowski that give rise to all these points that make you think that perhaps things have been skipped over here, that should have been looked into in more detail before this conclusion was reached.
I thought you were suggesting that this particular common law right is not a civil right.
Yes, I am suggesting that.
Or the decision is incorrect.
Yes, I'm sorry. I think I'm slightly cross-purposed. Our argument is that the right to enter one's country, which is the right with which QX is concerned, is not a civil right, and Strasbourg would so hold. What Lord Mance was directly talking about was the right not to be extradited, except in accordance with parliamentary authority, etc. He had made that jump from the common law right to automatically to a civil right. I'm not directly advancing argument on that. It really should be for an extradition case to do that.
I think what you said is it doesn't necessarily follow.
It doesn't necessarily follow, and the light way in which he skipped over from step to step here suggests that it may well be wrong, and there is reason to doubt whether it's correct. And ideally, that's as far as I'd like to go. But as I say, if I need to, I will go the further step and suggest that Pomachowski was wrongly decided and that these steps should not have been taken.
It's only the Halligan part of Pomachowski that you're...
That's right, yes. Yes. So below, I think we called it Halligan below, and it is only Halligan's case, yes.
I think the head note at page 1599, paragraph 4, really sums up your point, that it says, since the UK citizen has a common law right to enter and remain, and the extradition proceedings affect that, the extradition proceedings against him fell within Article 6.1, and you say there's a non sequitur in there.
Yes.
And you also say that he's talking about the right not to be extradited, but you refer to Mandura, which says that that is also not in Article 6.
Well, that's right. So that's another reason for thinking, if I put it the way we put it in writing, reason for doubting the correctness of Pomachowski. I don't have to positively submit it's wrong, but there are these reasons. So, lords and ladies, unless I can assist any further at this stage, those are our submissions.
Thank you very much, Mr. Chairman. Yes, Mr. Squires.
My ladies, I apologise, we hadn't picked up on the new practice directions. I'm afraid you're only going to be hearing from me rather than my very able juniors. Can I start by saying something about the factual background and about how the issues arise before you and why they matter to QX? The question before the court is whether Article 6 engages in challenges to conditions A and B for the imposition of a TEO. And that obviously has general application. But the reason it matters to QX in these proceedings, and the reason we thought until this morning that it mattered to the Secretary of State, is that it's determinative of whether QX is entitled to AF number 3 disclosure of the Syria allegations. And what Mr. Justice Farby held, and we had understood the Secretary of State's position to be to support that, was that AF number 3 did not apply to the Syria allegations. And that is why the case is of such importance to QX. As the court will know, he's always accepted that he was in Syria between 2013 to 2018. His family then crossed into Turkey towards the end of 2018, where they were detained, and they were then deported on the 9th of January 2019 to the UK. And as we'll see in a moment, the reason that the TEO was imposed on QX in November 2018 was in order to enable the obligations to be imposed on him. And we'll return to the relevance of that, but we'll see the evidence. But it's for obvious reasons that he was being deported. So the TEO itself had little or no impact on his ability to return to the UK. You've seen the definition of a TEO is something that prevents someone returning to the UK unless they have a permit to return or they're being deported. And we'll see, unsurprisingly and from the evidence, the reason the TEO was imposed in November 2018 was so that the obligations could then be imposed on QX when he returned. And there's nothing unlawful about that. That's perfectly proper. But we'll see.
And I suppose also to regulate the manner of his return, so that the authorities would be aware of his return.
We're accepting this case because he's being deported. We don't even know what the permit of return would have said, but presumably it comes from the Turkish authorities saying you're coming back on this day. The way the TEO works is that you need a permit of return if you're not being deported, but we'll go to the statute. But it says 2(1)(b), if you're deported, you're perfectly entitled for obvious reasons to come back.
So the what's going through my mind is clearly the obligations impose a measure of regulation over the person, the individual, once he's back in the country. But the TEO ensures that he only comes back into the country in a manner of which the authorities are aware and at a time of which they're aware, because either he'll be deported, in which case it'll be by agreement with the British authorities, or it's in accordance with the permit which specifies how and where and he can come back, he can return to the country.
Yeah, precisely. I'll come back to this. The TEOs do two things. They both allow the Secretary of State to control the return, and they allow the Secretary of State to impose obligations on return. And our case will come to it, is that conditions A and B is absolutely critical to the legality of both. The only point I make here is that, in fact, in our case, and we don't say there's anything improper in it, the reason the TEO was imposed, we'll see, was in order to impose the obligations after QX came back, because it was a deportation case, so he would come back when the Turkish authorities placed him on a plane. And the reason that the TEO and the obligations were imposed on QX was the national security case against him. It was the allegation of terrorism-related activity in Syria. QX's case, after he amended the claim to challenge the national security case and the imposition of the TEO, was he was involved solely in humanitarian work in Syria. The Secretary of State does not accept that.
So when his claim was limited to the obligations, he didn't expressly say what he'd been doing.
He didn't say, no, precisely. He said, I don't accept the allegation, but I'm not challenging it. We set out in our written case.
And that was because of for the same reason as he was concerned about the criminal investigation.
Precisely. He was arrested when he came back on what appeared to be exactly the same allegations, and he was, I think when he initially issued the challenge, he was still he'd been released under investigation. His concern, he didn't want to say anything about what he'd done in Syria, any detail at that stage. He explains in his witness statement why, with the passage of time, he did feel able, and he sets out an account of what he did in Syria. The Secretary of State responded to that by saying he didn't dispute any of his account of what he did in Syria, but said that wasn't the sole purpose of what he was doing. it's QX's case that he requires further disclosure in order to be able to respond properly. In his cases, he has not got AF number 3 compliant disclosure of the Syria allegations. And the key part of Mrs. Justice Farby's decision was that he was not entitled to AF number 3 disclosure of the Syria allegations, and you have that in page 131. So this was her order after the third judgment. At 130, the first part of the declaration, the review of whether conditions A or B is set does not engage Article 6. First declaration, and then the key one over the page, and we'll see it's because of one that she then made declaration 2. The claimant is not entitled to AF number 3 on the Syria allegations as defined in paragraph 2. Her judgment, if you turn paragraph 2, you have at page 162.
That.
My learned friend referred to this as well. There's a UK allegation, a very vague one, about what he did after return, but the Syria allegation you'll see is defined by Mrs. Justice Farby. While in Syria, aligned himself with the group that was itself aligned with Al-Qaeda and that he held a significant leadership role, I shall call this Syria allegations, and her order was not entitled to AF number 3 disclosure of the Syria allegations. And that has been why QX has sought to challenge Mrs. Justice Farby's order. And the reason that Mrs. Justice Farby reached that conclusion was her finding about conditions A and B not engaging Article 6. And one can see that in her third judgment, if the court is back in that page 1, paragraph 41, which you have at page 170.
Give the first one, please.
This is the third, apologies. This is explanation for that order, why he doesn't get AF number, he's not entitled to AF number 3.
Three paragraphs.
Page 170, paragraph 41.
The cure.
And what she holds, if you look at the last sentence, we'll see why she says it follows, but it's in matters touching on the imposition of a TEO, I've already decided Article 6 of the Convention is not engaged. That's because it's only concerned with the right of abode interference. See further up that paragraph. And she then goes on to deal with conditions A and B, page 173 of the electronic bundle, paragraph 59. Condition A concerns terrorism-related activity outside the UK, in this case the Syria allegation. Condition A was not an issue before the recent amendment of the claimant's case, but the amendment has no effect on disclosure. So the fact that he is now challenging the Syria allegations, she found had no effect on disclosure. Claim is not entitled to F number 3, disclosure in relation to condition A. It's reviewable only in relation to the imposition of the TEO. And the upshot of that was that on Mrs. Justice Farby's analysis, the Syria allegations could be solely or to a decisive degree kept in close. That's the AF number 3 standard that Bernard Fend, Mr. Gray took you to. He's not entitled on the Syria allegations to be given sufficient information about the allegation to enable him to give effective instructions in relation. Again, that's paragraph 59 of Lord Phillips. And of course, all of this matters to QX, not only because he is seeking to challenge what is a serious allegation against him, but also because of the conviction that he now has, having previously been a man of good character, he now has a conviction for a terrorism offence. And it's of obvious importance to him if he succeeds in showing it was not reasonable to suspect him of involvement in terrorism-related activity, he'll be entitled to have the obligations quashed, but also the conviction quashed which follows it. Turning to my submissions.
But before you do that, can you just help me on this? You say that was your previous understanding of the position. You say it's now changed.
Oh, I thought the Secretary of State this morning said that QX is entitled to AF number 3 disclosure of the Syria allegation.
That's my understanding too.
Certainly that was not our understanding, well, that was not the position. It certainly was not Mrs. Justice Farby's order. And the reason this has been fought, as we understood it, all the way here, was in order to avoid making AF number 3 disclosure of the Syria allegation.
Well, I thought he'd always accepted that in relation to the obligations review.
What had been accepted is that you can have disclosure of the national security case relevant to the obligations, but Mrs. Justice Farby's analysis was that that didn't include the Syria allegations because they could only be challenged in the Condition A challenge to the imposition. That's why she ordered as she did. So what was being said had been said up until now as, for example, things like the UK allegations. That would be disclosed on AF number 3 basis, but the Syria allegation, this is why we're here, this is why we appealed against Mrs. Justice Farby's order, could only be challenged on a Conditions A, Conditions B review. That was her decision. Matters touching upon the imposition could only be challenged. It didn't make a difference, she held, that he'd now amended his case to say this is what I was doing in Syria. That's why she then ordered you don't get AF number 3 disclosure of the Syria allegations. That was the logic of her analysis. What was now accepted this morning was, which may well make this case academic, and to that extent, what QX wants is disclosure. I'll come on to it. It makes the position even more incoherent. There is, we respectfully say, a logic to Mrs. Justice Farby's analysis, which said it's Condition A, you challenge it in Condition A. If you've lost on that, you can't then come back and say, but by the way, I'd like to have another go making the same argument. But we respectfully say there is a logic to that. But if it's the case, as it now appears to be accepted, that you do get AF number 3 disclosure on the Syria allegations at the obligation stage, then we do respectfully say it becomes entirely incoherent. The Syria allegations, reasonable suspect of terrorism-related activity is Condition A.
Yeah.
But as I'll come back to why we get there through the application of Article 6 principles. But that was the decision that we were challenging, and why it was being challenged by QX.
Mr. Squire, from my own perspective, I'm not certain what my colleagues are. I would like to have overnight, if you could provide it, a transcript of the various formulations that were put forward by Mr. Tam in relation to this very issue.
Well,
Because if that would be possible.
I wonder if it might be perhaps best if Mr. Tam were to provide us with a written note of his position.
Oh, yes, because I'm sorry, if I may, that does seem to be a bit of a misunderstanding of what I'd said this morning. Perhaps understandable given the complexity of the different rights in play. But if the court would receive one, then perhaps we should do a note on this, because I'm not aware of it having intentionally made any wide-ranging concession of this nature.
We might be assisted if Mr. Squires was also to produce a note of his previous understanding and have that modified during the course of the event.
Yes, I can.
I think it would help me if it focused on what is the point, which is, it seems to be disclosure relevant to the factual dispute between the parties as to what QX was doing in Syria, and at what point that becomes challengeable, and what evidence is disclosable as to that at either stage of these proceedings.
Yes.
Because I think we have come away with different impressions as to what Secretary of State's case is.
Yes. Yes, it's quite clear that different members of the court have a different understanding of what the Secretary of State's case actually is. And I think also there's a degree of uncertainty as to what are we actually arguing about here? What in practice is this appeal about?
Well, they said we will think overnight further about that. What I was going to continue to address was the Mrs. Justice Farby analysis, which we understood the Secretary of State was seeking to uphold, and that was AF number 3 does not apply to Syria allegations because, and then there was then a logical process that got there.
But I thought one of the propositions being put forward by the Secretary of State when he qualified potentially what he said earlier was that on an obligations review, they could decide not to refer at all to the Syria allegation. They could just refer to some further information they'd received. And accordingly, they wouldn't be supporting condition A or condition A. And so that by that device, well, not device, or by that route, they would avoid having to disclose anything about the Syria allegation.
Yes, I mean, it's certainly our understanding was that was the purpose, or the purpose of the Secretary of State seemed to uphold Mrs. Justice Farby was to avoid disclosure of the Syria allegation. But what we'll come on to is our submission is that, of course, without the Syria allegation, it is quite clear that the obligations were not necessary. That is why they were imposed. It's why the TO was imposed. And that is why the obligations were imposed.
It will depend on what the case is of the individual who is seeking the review. I mean, in a different case, you may be seeking a review on the basis that actually he was in the United Kingdom, and so condition C wasn't satisfied, in which case the court wouldn't need to go into conditions A or B. But assuming that his challenge is that condition A was not satisfied at any time, then we need to understand whether that is a relevant matter that the court can take into account in an obligations review.
Yes, yes. I mean, in fact, they'll come answer the first point they made, for example, about if the person said, "You just misunderstood. I was not in the UK. I was actually in the UK when you made this." We would say that's another. The obligations will then go. There'll be no lawful basis for imposing the obligations or imposing the TEO. We would say that is in exactly the same way, directly determinative in precisely the same way. So to give my lady's example, one would not even need to say these obligations were unnecessary, etc. One would simply say you had no power to make this order at all. It's a condition precedent that I was outside the UK when you made it. You got it wrong. That's it. These obligations are unlawfully imposed, and we are. Submission is that is straightforwardly determinative of the civil rights, or the legality of the interference. But that's a helpful analogy, a helpful example, because it shows that one may not be dealing with condition A at all. But the analysis and the logic must be exactly the same. You are still challenging these obligations, and of course, if you're convicted of breaching them, that would be quashed. Let's start my submissions with 3 points that are not in dispute. It's not disputed the obligations imposed on QX interfered with his right to private and family life protected by Article 8, and that those rights are civil rights for the purpose of Article 6. I think I won't take you to the judgment. My learned friend took you to some of the relevant paragraphs, but it's the complete set, I think, is 42 to 44 of the first judgment, which you have at page 132, 73 and 76. And the Court of Appeal accepted that was correct. Paragraph 118, page 92 of the electronic bundle.
Sorry, the proposition is...
Obligations imposed on QX interfere with his right to private and family life protected by Article 8, and that those rights are civil rights for the purpose of Article 6. It's not disputed.
And you don't even, I think, need to rely on Article 8. I mean, if you compel somebody to go and see an imam every week, that's obviously an interference with his ordinary common law rights to do as he pleases.
Be where he wants at that particular time. But yes. Point 2, it's not disputed that if you have proceedings or parts of proceedings which determine whether individual TEO obligations imposed on QX were necessary and lawful, those proceedings fall within Article 6.
Sorry, can you say that again?
Yes, it's not disputed that proceedings or parts of proceedings which determine whether individual TEO obligations imposed on QX were necessary and lawful fall within Article 6. And the reason we say that isn't disputed is that it appears in Mrs. Justice Farby's first judgment, paragraph 78, page 147.
How's that different from your first proposition? Is it the same?
The first proposition is that the
obligations
are civil rights. Second proposition is if you determine whether interference is necessary or lawful. 78, these proceedings will determine, of course, at this stage, I'll come back to the moment, he's only saying, he's not saying I wasn't in Syria, he's just saying it was disproportionate to require me to report 7 days a week, etc. Mrs. Justice Farby says these proceedings will determine whether the Section 9 obligations under challenge are necessary and lawful, in which case they will continue, whether they are unlawful, in which case the court will grant for relief. The court will consider and determine challenge the obligations which he makes under Article 8. In these circumstances, it follows Article 6 applies to the proceedings. And in the Secretary of State's written case, paragraph 1.7, page 34 of the electronic bundle, he specifically refers to this decision, to paragraph 78. And again, we'll come back to this. Perhaps I'll just ask it rhetorically now. Why isn't the argument that says the TEO was unlawfully imposed not a challenge to the necessity and lawfulness, and particularly the lawfulness of the obligations? If you say you were imposing obligations under unlawful order, why is that not a challenge to the lawfulness of the obligations, the legality of the interference? Third point, not disputed, is Mrs. Justice Farby's finding that the obligations imposed on QX were onerous and should be regarded as falling within the category of, quote, virtual imprisonment as described by Lord Mance in Tariq, along with control orders and asset freezing, and that a challenge to the obligations therefore attracts AF number 3 disclosure. And I can get the references to that are again first judgment, paragraph 83, electronic bundle 148, which I think my own friend Mr. Tam gave you, and that what Lord Mance meant by virtual imprisonment, the point that was picked up on by Mr. Justice Farby is paragraphs 47 to 48 in the first judgment, page 141 of the electronic bundle. We do say, and this will come back to the significance of this when I compare this to the control order regime, is that it wasn't a surprising, we say, with respect decision in relation to the obligations. When one looks at the control of the cases, and in particular, Mrs. Justice Farby referred to the case of BB and BC. If you're still in the first judgment, electronic bundle, page 140.
Paragraphs.
Paragraphs 39 to 41. But we'll come back to this point, but it's undoubtedly the case that there will be some control orders and TPIMs with significantly more restrictive obligations imposed, but that doesn't change the legal analysis. And if one looks here at BB and BC, if the court has that paragraph 39, you'll see the obligations imposed on BC and BB that Mr. Justice Collins was then considering. These are regarded as light. The Secretary of State contended that AF number 3 could be distinguished because the obligation was sufficiently light that they did not engage in human rights. And if you look at the obligation to reside at his present address, given his 2 working days' notice of intent to stay over elsewhere, report to nominated police station, surrender passport, not to travel outside UK, not to associate with BB. Now they are different to some extent to the obligations on QX. The residence requirement here is a little more onerous. There's the association requirement, but of course QX has the mentoring requirement as well. But these are pretty similar scale of obligations that are imposed under the control order. And what's clear from BB and BC is that Article 6 is engaged in a challenge where a person says it wasn't reasonable to suspect me of involvement in terrorism, and AF number 3 disclosure applies. A further point that isn't disputed is that conditions A and B are conditions precedent to both the imposing of the TEO and the imposing of obligations under the TEO. And it's not disputed that a successful challenge to the Secretary of State's decisions on conditions A and B not only mean that the TEO is quashed, but that the obligations made under it are quashed. And it's not disputed that any conviction for breach of the obligations would also be quashed. Again, for the court's note, this is the Secretary of State's written case 5.6, page 43 on the condition precedent. Condition precedent point, 5.5 of the written case, page 43, the acceptance that, quote, a quashing of a TO must result in the quashing of the obligation. And of course, they're not disputed that a criminal conviction would also be quashed if the obligation is quashed. That's 5.8 of the Secretary of State's written case, page 43. In terms of the issues that are in dispute, the Secretary of State's position, as we understand it, the argument has 2 stages. The first stage is right of abode of a British citizen is not a civil right. And that any challenge to conditions A and B is only a challenge to the interference with the right of abode. And as I say, we had understood the position was that on that basis he wasn't entitled to AF number 3 disclosure of the serial allegations because they went to and were challengeable in an imposition review in relation conditions A and B. Our submission is that is incorrect, and the way we've reversed the order as both parties have in terms of the argument, our first argument is that that's incorrect for essentially the reasons the Court of Appeal gave at paragraph 119. We say it's incorrect that a challenge to conditions A and B being met is solely a challenge to the interference with the right of abode. It is also, we say, squarely a challenge to the legality of the interference occasioned by the obligations. And then our second argument is, again, to adopt the same order as the Secretary of State. is to rely on the point left open by the Court of Appeal at paragraph 117, which is whether the right of abode is in any event a civil right. And as with the Secretary, I'll address the court and those in the same order. So turning to our first argument.
If it assists you, I think at the moment the first point seems, to me at any rate, to be the crux of the case. I mean, if one accepts that if all we were concerned with was the imposition of a TEO, then it wouldn't attract Article 6 protection. But is it enough that the satisfaction of the two conditions is a condition precedent for the imposition of the obligations? Is that enough to make the imposition of a TEO and a challenge to that form part of the determination of the civil rights? And when one looks at the language of the Strasbourg cases, in some they talk about they contrast a direct connection. Directly decisive is a phrase that's used, as contrasted with unduly remote. In other cases, there's vaguer language, affect or relate to. But it's the nature of what amounts to a determination of civil rights that seems to be critical.
Yeah, but I'll certainly address you on both or how that's put in Strasbourg and also how it's put in the Supreme Court considered that in G and the X case. I mean, our headline submission is that this is far more straightforward than that. It's simply dispositive. And I think there's no doubt at all, this is G and X school, is if proceedings or some part of proceedings is dispositive of the legality of an interference with a civil right, then Article 6 is engaged. There is more complications when it comes to proceedings that are not dispositive in that way. But our submission will be that with respect, our submission is this to that extent, this is straightforward. This is a challenge to the legality of obligations. If you challenge an order under which obligations are made and the order is unlawful, that is dispositive of the legality of the obligations.
And are you going to deal with at what point does it become apparent that the imposition of the TEO or the review of the TEO is going to be dispositive of the Article 8 interference complaint? Do you accept that there are some circumstances in which the TEO review does not engage Article?
Well, absolutely, and it's exactly the same with control orders and TPIP, as we'll see in a moment. If you had a control order that did not, for example, you could have a control order that simply stopped someone leaving the country or coming into the country. We'll see that in a moment. If you challenge that, it does not engage Article 6 on the Secretary of State's analysis because none of the obligations interfere with a civil right. So that sort of challenge, there's no doubt at all, would not engage Article 6. But if you are challenging an order which has obligations made under it which do interfere with civil rights, then Article 6 is engaged.
So you're accepting that you'd have to have an inquiry into, first of all, whether obligations have been imposed, secondly, whether the obligations interfere, and thirdly, whether the obligations interfere sufficiently to engage Article 8.
Absolutely, yes. And that's, for example, what happened in BB and BC.
I'm so sorry. If they don't, if all of those questions are answered no, then the imposition review doesn't engage.
Subject to our second argument about right to abode. I'm assuming now I'm wrong on right to abode. But if we're wrong on that, then yes, absolutely, exactly the same with a control order. That's why, generally speaking, the courts have MB, AF simply assumed, given the nature of the obligations, that if you challenge the order, the obligations made under it is sufficiently serious that Article 6 was engaged. There's very little discussion in MB and AF on it. BB and BC, you saw from the quote, the Secretary of State had come back and said, well, I've now produced a light control order, Article 6 not engaged. This was directly after AF number 3, so the idea was trying to avoid making AF number 3 disclosure. Secretary of State came back and said, Article 6 not engaged here. So to answer my latest one precisely, the court had to go through those stages and say, well, what's the nature of the obligations, sufficiently onerous, AF number 3 required, etc. So yes, we absolutely accept that you go through that exercise at the time when the challenge is before the court. So our first argument is challenge to conditions A and B determines dispositive of the legality of the obligations and therefore the legality of the interference with civil rights. They are we look at the various different language used by Strasbourg, but our respect is this is, we say, a pretty clear case. This is dispositive, but even if it isn't, we'll see what G and X school says about the matter. And we say it's right, first as a matter of principle, and I'll take the court to the Article 6 authorities. Two, we do say, in this regard, TEOs are indistinguishable from control orders and TPIMs. You could perfectly easily have a control order or TPIM that on the Secretary of State's analysis only interfered with non-civil rights. It could just stop the person leaving the country. If later on, in relation to that control order or PPIM, a whole series of other obligations were added, it would then be identical to the current situation. There'd be no doubt at all that Article 6 would be engaged and AF number 3 disclosure would be required. We'll see you can avoid AF number 3 in those circumstances, say, well, we originally imposed it when all we were doing was trying to stop you leaving or coming into the country. We've now imposed a whole series of additional obligations which undoubtedly interfere with your civil rights, but Article 6 is not engaged because of, this is now, in my learning friend's language, a two-stage process. We say the logic as to why Article 6 is engaged in challenges to the control order and TPIM applies equally here. It is because obligations imposed under it interfere with civil rights, and therefore if you challenge the order itself, you're challenging the legality of the obligations. And third, we also say that the distinction the Secretary of State seeks to draw, we say, is incoherent with respect. We say it's incoherent to say a challenge that says it wasn't lawful, a TEO wasn't lawfully imposed because it wasn't reasonable to suspect me of involvement in terrorism-related activity, and therefore the obligations made under it are not lawfully imposed, falls outside Article 6, but that a challenge to the individual obligations on the basis they were unlawfully imposed does fall within Article 6. We say that it's exactly the same thing. And if one puts it in Article 8 terms, it would be a prescribed by law argument that said you had no lawful basis for imposing these obligations. It was imposed under an order that you had no power to impose. So turning first to the Article 6 principle, that's our first strand of the argument. We set those out, and we set the arguments out, paragraphs 32 to 39 of our written case. And we say you get three things from it's both the Strasbourg and domestic authorities. I'm going to show the court two. One is that Article 6 is engaged in proceedings or parts of proceedings if the result of those proceedings is directly decisive of a civil right. We'll see that language. It's those two phrases, result and directly decisive. And what's second point is what directly decisive means, and we'll see this in the GNX school case, is dispositive of the legality of an interference with a civil right, or having a major or substantial influence on the determination of a civil right. And the third point we also make, and we'll see this in the GNX school case, is that in deciding if Article 6 is engaged, the court should not, in some, quote, artificial or excessively formalistic way, seek to separate out different parts of proceedings. It should not, and this is a quote from the GNX school case, give too much weight to the fact that the two sets of proceedings are as a matter of form separate, the focus should be on the substance of the matter. The court should always keep in mind the importance of ensuring the guarantees afforded by Article 6 are not illusory. We'll see where that appears in the Lord Dyson speech in GNX School. I was going to take you to two authorities, if I may, to make good those propositions. The first is the Regner and the Czech Republic case, which you have page 2145 of the electronic bundle. The court will see the background of the case from the head note. Applicant, the first line, employed by the Ministry of Defence as Director of the Department of Administration of the Ministry's property. The beginning of the next paragraph, National Security Authority received confidential information classified restricted from the intelligence service about the applicant. The authority H3 revoked the applicant's security clearance. He ends up, I think, resigning, but then challenging, but bringing proceedings. And what happens in the proceedings is he's not allowed to see, as often happens, the security information, and that doesn't appear in the judgment. And the question is whether there's been a breach of Article 6. And what's found is that Article 6 is engaged, but there isn't a breach in this particular case. And the key principles discussed paragraph 99, the heading applicability of Article 6(1) of the Convention, 2166. I apologise for the and this, as often in Strasbourg, is a repeated paragraph. Paragraph 99, we'll see it in some other decisions, but it appears repeatedly. Court reiterates for Article 6 applicable in its civil limb, there must be a dispute regarding a right, said at least on arguable grounds, to be recognised under domestic law, respective whether it's protected by the Convention. The dispute must be genuine and serious. It may relate not only to the actual existence of a right, but also to its scope and the manner of its exercise. And then the critical sentence for our purposes, the final one, finally, the result of the pleading must be directly decisive for the right in question. So that's the test, and as so often one does need to descend into the details a little, but that's the general formula that the Strasbourg court repeatedly used.
So sorry, it's my fault. What right was being adjudicated? He had to resign from his role.
Yes, so
an employment right.
So we'll come to that because the court deals with that in a moment. In the next a passage I'll show my lady in it shortly. Yeah, essentially it's that he loses his job because security clearance is a condition to him exercising his work. Paragraph 102 to 103. Can we no doubt about the fact that there is a right in the meaning of Article 6(1) where a substantive right recognised in domestic law is accompanied by a procedural right to have that right enforced through the courts. 103, it's not enough to have in effect a mere hope. This is talking about what the right is, but of course, again, applying to our case, a substantive right here is are the rights recognised in domestic law under the Convention, and there may be others, and QX has a procedural right to enforce those in TEO proceedings because accepted, he can argue, these obligations should not have been imposed on me. They interfere with my civil rights. And then, in answer to my lady's point about what the right here is in question, the analysis it picks up 113, page 2169, existence of a right. And we'll see why it's important for our purposes. 113 to 119, that looks at the existence of the right. And you'll see what the applicant says. Because of the revocation, this is 114, he has lost his function subsequent to his employment as a result of the decision revoking the security clearance. And then 115, in the middle of the paragraph, security clearance is not an autonomous right. So in that sense, he's not saying my civil right here was my right to see classified documents, but it's a condition sine qua non for the exercise of duties of the type carried out by the applicant, according to the loss of the applicant's security had a decisive effect on his personal and professional situation, preventing him from continuing to carry out certain duties at the Ministry of Defence. And so when the court then asks, and we'll come back to this, my Lord Reed picked up about there it does talk about tenuous or remote in paragraph 119, and we'll see that the GNX school case slightly tightens that up. But ultimately what one is looking at is the link between decision to revoke the security clearance, which in fact is not itself a civil right, and the loss of the duties was more than tenuous or remote. And that's because paragraph 118, the duties were conditional on authorisation to access classified information, therefore made it impossible for him to work. So again, if one applies that analysis in that case was looking at whether challenge to security clearance, not a civil right, nevertheless directly decisive, answer yes, because it's a condition on him being able to work. And the court explains at paragraph 117 why his ability to work is a civil right, or specifically him losing his job is an interference with a civil right. So if you apply that in our case, you say, was the reasonable suspicion that QX was involved in terrorism-related activity and that it was necessary to impose a TEO? What's the connection between that and the imposition of the restrictive measures on him? Whether you're applying a tenuous or remotely connected or a much higher test, in our case, it's simply dispositive. There are, as we say, conditions precedent. If he's done nothing wrong in Syria, clearly should not be imposing obligations on him, and it's a condition in the statute.
So what was decided in Britain?
They decide that Article 6 is engaged but not breached.
Yes, thank you.
Which paragraph is that?
The conclusion that it wasn't breached, or...
No, that it was engaged.
Scotland. To 122, but maybe let me get. I think these were the preliminary objections raised by the government, was that it wasn't an Article 6 case. Can we look at that, maybe? I apologise. We can maybe find the exact reference. Yes, it's the applicability of Article 6 of the Convention, 2166 is heading B, and I think it was an objection from the government that it didn't apply. That's rejected. It then goes on to consider whether the process was a fair one, and that's all to do with access to the security information. The second case was the GNX school case. I was intending to take you to page 1401.
Sure.
And the court will see again that the factual background in this case from the head note. Claimant was employed as a teaching assistant at a primary school, and he faced disciplinary proceedings for having allegedly formed an inappropriate relation with a 15-year-old boy, undertaking work experience. He's dismissed by the school, and he's not permitted to have legal representation. One of the effects, one thing that followed the discipline committee, the matter was referred to the Secretary of State, who through the Independent Safeguarding Authority, the ISA, this was at the time, had the power to bar the claimant from working with children. And so the way in which what the court analysed here is what happens if you have two sets of proceedings. One, proceedings before the governor, the governors, which was said not to engage civil rights, and then subsequent proceedings before the ISA, which, because they could bar the individual from working with children, it was accepted did engage civil rights. Question, what should the connection be between those two sets of proceedings for some of the safeguards in Article 6 to be required in the first set of proceedings? And the analysis is the conclusions are paragraph 63 to 69, page 1426 in Lord Dyson's speech. And on this point, Kerr dissented on the outcome, but he agreed, paragraph 103, and as did Lords Walker, paragraph 1, Lord Hope, 86, and Lord Brown, 96. So this is the view of a unanimous court on this point. And the court will see the analysis here, and this is...
Was it assumed or decided that the dismissed proceedings within the school did not engage Article?
It seemed not on their own, I think. It's paragraph 34. Article 33 explains common ground, civil rights, right to practice his profession as a teaching assistant. No doubt that would be directly decided. But it seemed to be accepted that it wasn't without that. I think the view was it wouldn't necessarily be engaged at the first stage. Wouldn't be engaged in the disciplinary proceedings. In fact, one of the points I think Lord Brown makes, the court ultimately concludes that it applies a test, which is what we're going to look at from Lord Dyson's judgment, which the court does agree on. When it applies the test, it finds there isn't a sufficient connection between the later proceedings and the earlier one. The points that I think is Lord...
Well, in 33, isn't it saying that because the outcome of the disciplinary proceedings, i.e. a finding that she did form an inappropriate relationship, would be very powerful influence on the later barring proceedings, that meant that the disciplinary proceedings engaged articles.
Yes, that was the argument. The argument was because of the influence that the disciplinary proceedings would have on the later barring decision, Article 6 applied at the earlier stage. What the Supreme Court does here is they set out the test for that connection between the two, but ultimately, with Lord Kerr dissenting, finds it doesn't have a sufficient influence because they find that the ISA would make its own decision.
Without the connection, Article 6 had no role to play.
Yes.
Discipline.
Yes, precisely. So that's the conclusion ultimately of the majority is...
Well, that's the step in the reasoning. You need to have the connection.
Yes, precisely. And what, for our purposes, what's relevant is what's the test for that connection. And what had happened here is that the Secretary of State in the school had said the test for the connection is that it has to be dispositive. And we'll see that's rejected by the Supreme Court. But it also doesn't accept mere tenuous is enough. It explains what the level of connection, and that's the part that's we rely on. And that's the part at 63, page 1426 through to 1428. And what the court will see, paragraph 64, is certainly dispositive. Proceedings A, dispositive of proceedings B, clearly will be. That's a...
Can I just ask you, does dispositive mean either way or only one way?
I'll come back to that, if I may, when I deal with my learned friends' submissions. Our submission is certainly if it disposes of it on the basis, or it is capable of concluding it was unlawful and quashing, that must be dispositive. The fact that you may have a subsequent, another argument available to you.
Well, it's not dispositive if it upholds it. It's not dispositive dispositive at all.
If it upholds the
Imposition. If the TEO imposition is upheld,
yes,
that doesn't dispose of the question whether the obligations are lawfully imposed.
this my learned friend says because you then have another chance to say it shouldn't have been 7 days a week or 4 days a week. I mean, it's dispositive in the sense it might well be found to be lawful, but of course in proceedings you could find dispositive unlawful, you could find dispositive lawful, but either will be dispositive in that sense. It doesn't only have to be, well, it may well decide the interference with your rights was lawful. And it may be, this way I won't come back to deal with my learned friend, but learned friend's point is, well, you might fail at your first stage. You might be unable to show that it wasn't reasonable to suspect you involved in terrorism, but you might be able to show that, well, 7 days a week was too much. It should have been 4 days a week. Therefore, he says, not dispositive, but that can't conceivably be right. The fact that you've got two arguments available to you, which may succeed in showing an interference was unlawful, doesn't mean that because one may fail, but the other may succeed, neither is dispositive. And you can see that from the control order context. In the control order context, it's exactly the same. A person can come forward and say, no reason to suspect me of involvement in terrorism, shouldn't have imposed this order, and they may lose. They may still win on the basis that it shouldn't have been 7 days a week reporting. But it's clearly not the case that means Article 6 isn't engaged at that first stage. The fact that you've got another possible argument that you can't run at the first stage, well, 7 days a week too much. The fact that you might still win on that argument doesn't mean that the first argument isn't dispositive. Say otherwise, control orders would all fall outside Article 6 because it's exactly the same. So it's an answer my latest point. Yes, we do say dispositive will be obviously dispositive. Yes, there was interference. Can be dispositive. No, there was no interference. It was perfectly lawful. Dispositive is clearly sufficient. As is at the letter E, cause irreversible prejudice to the applicant, but they don't say that's a necessary condition. The court then holds at 66, probably nearly more than tenuous is probably not enough, beginning of 66. What the court does, paragraph 67...
Before we go to that, 66, fourth line from the foot of the page, is perhaps relevant. Ruiz Mateos. Capable of affecting the outcome.
Yes, that's another.
That's picked up in the next paragraph where it speaks of. Is it the next paragraph? No, it's 68. Capable of being dispositive.
Yes. Yes, well, that will be helpful. Yes, well. Yes, well, yes, absolutely. We certainly adopt that. Is that language perhaps better than dispositive? Is capable of being dispositive is probably more accurate because one may lose, but it's certainly capable of being dispositive. And then one looks.
I don't think the distinction they were drawing was this one way or the other distinction there. They're discussing different formulations of where it is on the spectrum between being tenuous and being dispositive.
Well, I think that's right. I suppose this was a point about whether dispositive can be one way or the other. That's his recap. The other point, I think, my learned friend's point is a slightly different one, which is where you may still lose, but win on another. You have another argument available to you by the obligation stage. But our respect is that cannot mean Article 6 isn't engaged because you have another way of winning. That's control. It's exactly the same.
Yeah.
But yes, but may well be right that that's not that the court isn't concerned with that particular issue. 69. It says Lord Justice Laws had a useful formulation. which is substantial influence or effect. It captures the idea of the outcome proceedings, A, being capable of playing a major part in the civil rights determination in proceedings, B. That is what fairness requires. And this is why I got the language I quoted before. Anything less would be excessively formalistic and give too much weight to the fact that the two sets of proceedings are, as a matter of form, separate. The focus should be on the substance of the matter. The court should always keep in mind the importance of ensuring that the guarantees afforded by Article 6 are not illusory. And then over the page sets out the test, and it is accepted. It doesn't have to be dispositive. You can have major influence on the result of proceedings.
Whereabouts, sorry?
Sorry, this is A over the page, or A on page 1428. There's not a great matter of substance, not much difference between major influence and outcome of proceedings dispositive. In each case, civil rights greatly affected. And again, our submission is that our case is much more straightforward than this. We're not talking about two sets of proceedings in the way envisaged here. There's one set of proceedings, and challenging and condition A and B is critical to the legality of the obligations imposed under the order. Therefore, challenging that is a challenge to the legality and necessity of the obligation. So we say that's a straightforward dispositive case. But if one does seek to divide up these proceedings into different parts in the way the Secretary of State does, we say it would be precisely artificial and a particularly extreme form of formalism to say that a challenge that, if successful, would mean the TEO and the obligations is quashed, is nonetheless not determinative of the civil rights because of the particular structure of this regime. We see that is precisely the vice identified by Lord Dyson, giving too much weight to the fact the two sets of proceedings are a matter of form separate. Focus should be on the substance of the matter. The court should always keep in mind the importance of ensuring the guarantees afforded by Article 6.1 are not illusory. And we would say they would be if one ends up with an analysis that says challenge to the legality of the order is somehow distinct from, doesn't engage Article 6, when that is the condition precedent for the imposition of the obligations. That was all I had to say about the GNX school case. I don't know if that's a convenient place to...
Yes, I think it would be, Mr. Squires. Thank you. And the court will adjourn now and resume at 10:30 tomorrow.